What's up, guys? I wanted to do lawsuit video number 7 before road rage, right? I wanted to give just a little bit more of myself to you before road rage, which sounds really pretentious, and it is, and I'm okay with that. So the reason I'm doing lawsuit 7 is twofold. First, some documents did drop in the lawsuit, and I said that I would definitely keep covering the lawsuit as documents landed, and we'd go through them and talk about what happened. I'm eagerly awaiting the answer from Dick's legal team, and Asterios' legal team, and Maddox's, and everybody's legal team. I want to see what comes in, what theories they use, and when they do, I will make sure and create videos on all of them. That's the first reason. We have a couple documents. The second reason is I want to, let's say, marinate in certain sections of the original lawsuit document, the summons and complaint that we have. And the reason is there's a lot to cover here if you don't know what the law is, like Maddox. If you don't know what the law is, I can teach you some lessons on that. And I figure we should probably do that. Like I said, Maddox doesn't seem to know what the actual law is, the laws he's citing to in this document. I should probably say Maddox's attorneys, but I feel like if I actually attribute this document to Maddox's attorneys, they might sue me for defamation because they're so bad. They're just so bad. So, first order of business, let's take care of the documents that dropped. The documents that dropped on November 29th and November 30th are really basic. This will take just a second. These are affirmations / affidavits of service. They're really just kind of form documents, right? These are not things that require any sort of analysis. They're documents stating that the parties listed were served on specific dates, right? So, for example, the document dropped on the 29th of November. This is an affidavit of service stating that someone from the Landau Group or someone working on their behalf personally served the individual. So the first one is Joshua Kaufman, who, if you'll remember, is the attorney for Weber Shandwick, right? So they served Joshua Kaufman for Weber Shandwick. They served Joshua. Really? Okay. Okay, I'm wrong. I'm absolutely wrong. There's something interesting here, and we'll go with it. I don't know. Obvious disclaimer, I'm not a New York attorney. So what I'm going to say, I don't have expertise in, but I find it interesting that they would choose to do it in this way. Okay, so the first document here is Joshua Kaufman, who's the attorney, who is listed in the lawsuit. Yes, they sued the attorney of Weber Shandwick, I guess, and not in his capacity as an attorney, right? Like, if you're suing a person on behalf of a corporation, that's one thing. Like, I'm going to sue I'll sue Tim Cook in his capacity as CEO of Apple. If I have a cause of action against Apple, that would be up at the corporate, the top echelons of the corporate level. If I have a cause of action against Tim Cook, I serve Tim Cook, and I name him in my complaint. That's what Maddox has done here. Maddox has not only sued Weber Shandwick and Asterios, but they've sued the attorney Joshua Kaufman in his individual capacity, not in his capacity as an attorney. This is probably just a stupid mistake. Same thing goes with Bozer and Baker, I think, from the Foundation Digital. Like, they're named individually. Same thing with Jordan Cope of Patreon. Like, why are you suing Jordan Cope if you're mad at Patreon? Like, he's an employee. It'd be like going to Best Buy, getting crappy customer service from Tina, and suing Best Buy, and then suing Tina. Like, did she hurt you, or was she representing Best Buy? If she's representing Best Buy, you sue Best Buy, not their agent. So they're suing Joshua Kaufman in his individual capacity. This is just poor form, bad drafting, whatever. So that's the first one. So they individually served him. The next one is interesting. So I'm going to save that one, and then the last one is Weber Shandwick, and they served Joshua Kaufman as general counsel for Weber Shandwick, and that's okay, right? He's probably they should check on this, but he's probably authorized to accept service on behalf of Weber Shandwick in his role as general counsel. Not necessarily, but probably. But this one's interesting. So they served Asterios by giving it to Joshua Kaufman. Okay. And they also mailed it to Asterios as well. I'm not sure that's effective service. Like, Joshua Kaufman doesn't have, to my knowledge, maybe Maddox knows something I don't, but he doesn't have special relationship with Asterios Kokkinos. They have him listed as a suitable person by delivering thereat a true copy of each to Joshua Kaufman, a person of suitable age and discretion. Like, again, does Joshua Kaufman know Asterios? Does he have interactions with Asterios? Are they in the same building? Do they have a work schedule that coincides? Typically, and again, I'm not an attorney in New York, this might be perfectly acceptable. But if I'm serving someone in my capacity, I'm not serving a similar an adult at this person's workplace. I wouldn't even serve the person's boss at the workplace because they don't have a significant enough relationship to merit service, in my humble opinion. When I think suitable person for service, I think like a spouse who lives in the home with them, or maybe another adult who lives in the home with them. But like serving a person at their work that doesn't have a direct supervisory attachment, even, that's a little bit of a stretch. So service may be improper here, and this just, to me, is it just shows like the repeated carelessness. The person serving process was Raymond Hollingsworth. He's probably just a process server in New York, or maybe an employee of the Landau Group or something. Who knows? Doesn't matter. Pay him the extra $20 to give it to Asterios directly. Like, what are you doing? Why would you do it in this way? This is one of those things that could potentially raise problems for you down the road. And you're cutting a weird corner here. But like I said, all in all, it's probably fine. It's just a weird choice. Like, if you're at the building, just find out where Asterios is and go give it to him. Anyway, so that's what's done here. The service to most of the parties. There are a couple parties still missing. Presumably, they have not been served yet. Who knows? Maybe the documents just haven't been filed. We'll keep watching it and see what happens. Moving on from that and into the fun stuff. For me, anyway. I'm going to go through the causes of action, explain the alleged infraction in legal terms using references which are notably absent from the complaint in describing what they are. And I'll try and walk you guys through these alleged infractions so that you can understand the legal basis behind it. And that might be interesting. And then we'll see if the legal basis matches up with what's going on. And I'm going to try and do a video on each of these. It'll take a little time to go through some of them. So I'm going to start actually with a shorter one because I don't want to do an eternal video yet right before Road Rage. So I'm going to... Road Rage is a live show, by the way, that's coming up. If you're not caught up on Dick's podcast, Dick is doing a live show. And a lot of fans are going to be there, and some will be traveling, so I thought I would do this video so they might have something to listen to. But it's already late, so I don't want to do a super long one. So I'm not going to start at number 1. Number 1 is a long, jumbled mess. We're going to start here at number 7. Because this is a weird one. And it's entertaining to me. The 7th cause of action is conversion, and the named defendants are Herrera, Kokonos, Burt, and Foundation Digital. All right. So this starts off at paragraph 171, where the plaintiffs repeat, replete, and incorporate by reference each and every allegation of paragraphs 1 through 170 of this complaint as set forth in full herein. Great. Here's where the allegation starts. Defendants converted a variety of documents and virtual information of plaintiffs. I'm not going to complain about these apostrophes. Including but not limited to computerized lists of plaintiff Uzunian's fans, sponsors, and business associates, and information and documents related to plaintiff's business and websites and other social media accounts maintained by each plaintiff for their respective careers, and private information including phone numbers, addresses, account information, and passwords which were created and maintained by plaintiffs. Woohoo! That's a big jumbled mess. So first, we've got to find out what conversion is. I talked about this briefly in the other video, but conversion is when you take something that someone else has and you prevent them from using it. So you're exercising control over their personal property. Conversion does not work on like real property, real estate. It's very much a personal property crime. I mean, conversion's a crime, but it's also it's a civil matter as well. So this is useful. This is from 2015, Supreme Court, New York County, New York. This is Marsh USA Incorporated versus Alliant Insurance Services Incorporated. And this is handy because there's a definition of conversion, and it involves some things that I think might be similar to Maddox. So, a conversion takes place when someone intentionally and without authority assumes or exercises control over personal property belonging to someone else, interfering with that person's right of possession. That's really important. So the two key elements, this is still going in the case, two key elements of conversion are 1, plaintiff's possessory right or interest in the property, and 2, defendant's dominion over the property or interference with it in derogation of plaintiff's rights. That's the kicker. You can't just exercise control over something. And let me think of how we can phrase this, right? If I come into your house, right, and you've got a book that I really want, and I have this miraculous unlimited time, and you have a copy machine, and I photocopy every single page of that book, and then I leave you the book, and I run away, you have a possessory right or interest in the book. That's the property. And then I have exercised dominion over that property or interference with it, right? I have taken control of the property or the subject matter of the book. Like I've taken it. I've made copies with it. I've handled the book physically. I've taken it into my possession for a long enough time to make copies. But if I leave the book and leave, I haven't done it in derogation of your rights, because when you get home, you grab the book and you read the book. And I have not stopped you from doing that. That's not conversion. That's not conversion. Conversion is me preventing access to you. If I take your car and drive away with it and bring it back to you, like I haven't stolen your car because it's not gone, right? But I'm exercising control of it to the point where you're not able to. A better thing would be like if I attached a boot to your car and prevented you from driving it. I've exercised control over your car and prevented you from having any control over your car. You can't drive it around. If I remove if I steal all the bolts from your bike, Maddox, because I know cars are difficult for you. So if I take all the bolts out of your bike and it's just a heap of parts on the ground, but I leave you all the heap of parts, that's conversion, because you can't use your stupid bike in your stupid bike lane. Yeah. So that's what conversion is. So Maddox is alleging that they converted a variety of documents and virtual information. This is a big claim, right? Because they're stating that Dick, Asterios, Tab, and Foundation Digital took documents and virtual information and somehow prevented Maddox from using or accessing that information. We'll see. Including but not limited to computerized lists of plaintiff Uzunian's fans. Okay, here's another element. Like the plaintiff has to have a possessory interest in the fan. So or possessory interest in the property. So if Maddox has to possess or own that list of fans, that has to be his possession. If we try and link this back to the facts, right? Like Maddox has alleged that Dick did targeted advertising to his fans, which you do through Facebook, right? You target the ads of someone who has liked particular content. In this case, I believe the allegation is that Dick did a targeted ad buy. September 5th, defendant Herrera bought a targeted advertisement on Facebook, targeting plaintiffs and their fans directly, suggesting that plaintiffs' followers should unsubscribe from his podcast. And so, yes, one reason you're seeing this ad is that Dick Masterson wants to reach people interested in Maddox. Writer. You have right based on activities such as liking pages or clicking on ads. Okay, so if your allegation, like if you don't reference your own facts, which is frustrating enough, by the way, when you have your facts section and then you have your cause of action section, you know what helps in your cause of action section? Reminding the court and anyone else reading the actual elements of the cause of action. Now, you may not have done this because you're deficient in your elements, but the trick is you lay out the elements of the cause of action and you either cite like a statute or a court decision that lays it out if it's common law, and then you match the facts that you listed earlier to your frickin' cause of action. So here, you should have listed out what a conversion is, what the two-part test is under New York law, judged by New York courts. Like this is a simple thing. And then you say that they converted a variety of documents. That's a legal conclusion. You have to show how it happens, right? We've covered this. So how do you convert a computerized list of plaintiff Uzunian's fans? You have to say where that list came from, because right now the only list we know of is your stupid targeted ad thing in section 30, in paragraph 39, which you could have referenced, see paragraph 39. That's all you had to do. If that's what you mean. I don't know if that's what you mean, because if that's what you mean, then you don't have a possessory interest in that list. Facebook has a possessory interest in that list alongside of you. And most importantly, by Dick advertising to them, he is not removing your possessory interest or derogating your interest in that list. He can't prevent you from having access to the list of your fans by buying a targeted ad. Even if your fans all leave, they're no longer yours. You no longer have a possessory interest in that thing. And by the way, you can't own people, Maddox. That's the 13th Amendment. Anyway, so computerized lists of Plaintiff Azunian's fans, sponsors, and business associates. Where do you get these lists that you're talking about, and how do you no longer have them? You have to lay these elements out. And information and documents related to plaintiff's business and websites. What documents does Dick have that you no longer have access to? Are you saying he took your hard drive or somehow compromised it so that you can't access it but he can? Because that's basically what needs to happen here. Like, he has to remove your access to these lists. If you're just saying that he took lists or information from you and used them, that's not conversion. Never is that conversion unless you cannot use them due to his use. Making a copy of something is not a conversion. Okay. Private information, including phone numbers. You can't convert a phone number. Like, I mean, okay, maybe if I like somehow convince the cell phone company to give me your cell phone number temporarily or something, like some like weird SIM card swap or something, maybe you can convert a phone number. But like disclosing a phone number to someone which didn't happen. First of all, that's not conversion. Like, disclosing a phone number, even a private phone number, even some super secret phone number isn't conversion unless they somehow prevent you from using that phone number, right? That's the second element. Addresses. How on earth can you convert an address? That's impossible. You can still use your address. You can't take that away from someone. This is where I live, or this is where I receive mail. Nope, that's not where he receives mail because I'm receiving it there. That's not how it works. Like, if you either receive mail there or you don't. And you would have full control over that with the post office. Unless you're alleging he went to the post office and did a change of address and forged your signature or something ridiculous so that he got stuff there and your stuff was all rejected. I don't know. Or he had it forwarded. That'd be funny. That'd be a conversion of an address, maybe. Account information. How are you no longer able to access whatever account you're talking about? And you probably should talk about it, because it doesn't make sense for anyone who knows anything about conversion to think of an account and being excluded from it unless you allege that he like changed a password and prevented you from accessing an account that was yours. And that's another key. Has to be yours. And passwords, which were created and maintained by plaintiffs apostrophe. Okay. How did he convert the password? Plaintiffs owned and had the right to possession of said personal property and information. I mean, some of it, maybe. Yeah, okay. That's fine. Defendants took unauthorized possession of plaintiffs' personal property and information and acted to exclude the rights of plaintiffs to use said property. How? How did they do that? And or is not going to help you use plaintiffs' property and information in their business and to defame and harass plaintiffs and their business associates and friends. First of all, there are too many commas there. You don't need them. Second of all, defamation and harassment are not elements of conversion. Ever. You can defame someone using private information and not convert that information because the person... Actually, no, you can't. You can't defame someone with information, because if it's information that they've taken from you, then it's true. So if they use that information, it's not defamation. So you can't defame someone with information that they've taken from you, I guess. They may be committing copyright infringement. They may be harassment. Maybe. But again, that's not your cause of action here. Your cause of action is conversion. So you have to talk about how they exclude the rights of you to use said property. What property are you referring to, Maddox? Defendants used plaintiff's stolen property in their business, not conversion, and transferred it to thousands of third parties, not conversion, on their websites and social media, and currently store said converted property on Defendant Foundation digital servers. But did they remove the property from you, or actually not remove the property from you? That would be theft, right? Conversion. How does any of that amount to you not being able to access that property? If we take at face value the fact that you said they took something you had a possessory interest in, I'm really curious. Because I think I know what you're talking about. And it's really interesting because didn't you do this? Like, didn't you actually do this thing first? So there's two options here, Maddox. Like, you maybe you converted something, right? I don't even know what the second option is. I don't see why you wouldn't list factually what you're alluding to. The judge doesn't know. The judge's clerk doesn't know. And again, if he does, you're screwed, because if they know what happened, you're toast, pal. Defendants... Okay. Likewise, defendants encouraged and incited their fans and followers to locate and access private information. This isn't an element of conversion. And documents of plaintiffs to use in their harassment campaigns, whereby they awarded their fans for bringing such private information and documents of so they could use in their shows and other social media sites. Okay. That has nothing to do with conversion. Not a thing. Not a thing at all. To do conversion, you have to take property that you have a possessory interest in. Oh, I want to go back to that lawsuit because here we go. So, I don't know the facts of this case that relate to conversion, but let's see if we can figure it out. Okay, so Marsh is... I'm going back to Marsh USA Incorporated versus Alliant Insurance Services. And I'm going to read this as fast as I can. The background's actually really short, and then we'll get to the facts of conversion. So Marsh is a corporation that provides surety-related service. Alliant is a direct competitor of Marsh. The individual defendants are 3 former high-level Marsh employees who resigned from Marsh to join Alliant in May 2015. Individual defendants entered into employment agreements, the non-solicitation agreements, containing non-solicitation clauses that restrict the solicitation of Marsh employees or clients for a period of 12 months after the end of employment. Additionally, Moylan's and Bly's non-solicitation agreements contain confidentiality clauses that prohibit the dissemination or disclosure of confidential information or trade secrets. In addition to his non-solicitation agreement, Saul has also signed a confidentiality agreement that contains the same language as confidentiality clauses in Bly's and Moylan's agreements. On December 15th, 2014, Moylan was demoted and advised that he would be terminated effective December 31st. First. Marsh later agreed to extend the termination date to no later than December 31st, 2015. Sorry, it was 2014 first. Moylan forwarded a number of documents to his and his wife's personal email addresses. He took emails, right? Both before and after December 15th, including 2 Excel spreadsheets identifying revenue and client names, right? This is going perfect. Maddox, we're on a roll. This sounds like your thing. And a 2014 service level agreement between Marsh and a client. The individual defendants left Marsh for Alliant in May 2015. On May 13th, 2015, Saul resigned from Marsh and began working for Alliant. On May 28th, 2015, Moylan resigned from Marsh and began working for Alliant on the same day. On May 29th, 2015, Bly resigned and began to work for Alliant. Moylan corresponded with Marsh clients on May 29th to announce his employment with Alliant as Managing Director of International Surety and relay his new contact information. Subsequently, several clients followed Moylan and Marsh to Alliant. Other Marsh clients followed Bly to Alliant. Okay, so the part that we care about. He forwarded emails to his and his wife's personal accounts, including 2 Excel spreadsheets identifying revenue and client names, and a 2015 business plan, which included revenue and client information, his Outlook contacts, including client contacts, and a 2014 service level agreement between Marsh and a client. So that sounds like pretty similar. Like what did we say here, Maddox? Like a variety of documents and vital information, including computerized lists of fans, sponsors, and business associates, and information and documents related to plaintiffs' businesses and websites. Cool. That's exactly what happened here. So, I already read the elements of conversion. There's one more paragraph. That's how long it takes the court. Marsh has a possessory right in the documents that it alleges defendants have unlawfully taken. However, Marsh has not shown that the defendants took or interfered with the property in derogation of its rights. Marsh has only shown that the individual defendants sent emails containing documents to personal email accounts belonging to the individual defendants or their spouses. There are no indications in the moving papers that the defendants used this information to derogate Marsh's rights, since the lists were merely copied rather than destroyed or taken. Therefore, Marsh has not shown that it is likely to succeed on the merits of its claim for conversion. Who does that sound like? Get used to that phrase, Maddox. Not likely to succeed. Not just in the lawsuit, buddy, but I digress. Taking unauthorized possession of property that is electronic means they have to remove your access to it for conversion to be a thing. And if you remove the access to the property, like you're probably not converting, you're probably stealing at that point. Like, because if I forward an email and delete it, I suppose I have in some way stolen it. Like if I permanently remove the email, I may have stolen the email at that point, or may have stolen the information. But to say you converted it would be to imply that they took copies and you still have the info, but somehow you're not able to access it. And you don't say how. You don't cover that because you don't know, because it didn't happen. And that's the real problem here. And I think what you're referring to are copies of The Biggest Problem show, right? Like that's what you're referring to. Let's just put it on the table. You're talking about podcast episodes, which you took first. If you don't remember, you converted the RSS feed. So you took them. And now you're saying that, I think, I'm inferring here, you're saying that Dick took those episodes and somehow barred your access to them. But don't you still have them listed and hosted? I mean, if you do, that'd be funny, right? Right? I wonder, what happens? Biggest problem in the universe. Biggest problem in the universe.com. Biggest problem in the universe. All the problems in the universe in descending order. Maddox's website. I've made this archive as complete as possible. You're welcome. You say the show had 105 episodes. Listed are episodes 1 in ascending order all the way to episodes 107. You have all of the problems ranked with their votes. Let's say, what happens when I click on an episode? Hey, there you go. There's a SoundCloud link. There's a transcript. No, wait a minute. Okay. So what's the deal? you have this. You have all this stuff. It's right here. Like, I mean, I knew, obviously, that you even have the bonus episodes. Weren't these paywalled? Did you get permission to release them from your business partner? I don't know. That's weird. You have the info. You have it right here. So you must not be referring to the podcast. My mistake. I guess I was just inferring it. You don't list in your statement of facts the facts of the documents that were taken. That would help. That would help a lot. Like if you said, here's a list of documents that were taken. Okay, what you've listed and what we can link to the facts is lists of fans, but you can't show that those were taken because he purchased advertising rights on Facebook. That's not taking something, for one thing, and that's not preventing you from, like, you could do the same thing, right? And by the way, Facebook has a possessory interest in those, not you, and they have the license to sell that list of advertisements. Check your terms of service, Maddox. If you want to have a Facebook fan page, you got to deal with the fact that Facebook owns the access to those fans to a higher degree than you do, because they have the right of alienation. They can sell them. You can't. I mean, I guess you could, but you'd have to sit there with like a pencil and put it, write down the names, and that'd be really inconvenient. The convenient way to do it is to buy them from Facebook. So, I mean, that's it. You don't lay out any case for conversion. At best, no, there's no at best. You allege other crimes in your conversion section. Harassment, incitement. You kind of allege theft by incompetence. I mean, you're not trying to, but that's what you have to mean. So, yeah, and you don't list any facts. So that's conversion. Does Maddox succeed on conversion? Let me see. I'm going to check my magical court 8-ball. Maddox has not shown that he is likely to succeed on the merits of his claim for conversion. Not at all, you dummy. You can't just say things in a lawsuit. That was your fact section. Your fact section was your chance to say things, to say what happened. These things happened. This thing was taken. That thing was removed. This person was harassed by this other person. Here's how they did it. That's your fact section. Once you get to a cause of action section, you need to lay out the law and you need to relate it to the facts. And if you don't do that, you fail. And you fail badly. And this kind of lack of care and preparation, lack of astute business decisions is probably why you failed at keeping the biggest problem afloat, why you failed at attracting your fans from biggest problem. People who liked you. You failed to get them to follow you to Best Debate because you made poor decisions over and over. And the biggest one is probably that failure of a podcast network that still only has 2 shows on it after, 2 years you haven't found another podcast to put on it? What's wrong with you? What network, why bother having a network if you're not going to have shows? Oh my goodness. Sorry. I gotta stop. From my heart. That's all I got for you guys tonight. 7th cause of action is deficient. When road rage is passed and I have some time next week, assuming no hot documents drop, I'm going to start going through these, and we're going to start with the big one. We're going to start with number 1. It'll be a long video. I apologize. It's not my fault that some dummy decided to write like 15 pages of nonsense. That would be Maddox's fault. But stay tuned, and thanks for watching.